Good afternoon, everyone. Thank you so much for joining us today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we are going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So it's just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are offering at least 2 webinars a month on different immigration law-related topics, so feel free to follow us. At the end of this webinar, we will be sending out a few things to all participants. First, we will be sending out a copy of the PowerPoint that will be used in this webinar. Second, we will send out a visa guide, which is a comprehensive guide to the extraordinary ability visa categories that you can use as a reference. Third, we will send you a link that you can use to sign up for additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will be made available on YouTube, and we do encourage you to subscribe and hit the notification button, as we do regularly upload a variety of immigration law-related videos that are very informative. Finally, we will send out a link that you can follow to set up a consultation with one of our experienced attorneys, should you wish to discuss your case further. Today, we're very lucky to have Kelly Weiner, who is managing partner of the firm with a wealth of experience handling cases in all of the visa categories that we will be speaking about today, who will be presenting about these various options available to the extraordinary ability individuals and the requirements and major considerations. Finally, for any question you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jiyae. Perfect. So we're going to get started today just talking about a few of the most common extraordinary ability visa categories, both temporary and permanent, meaning green cards. So first we have the O-1A visa. So this is a temporary visa for individuals with extraordinary ability in the sciences, education, business, or athletics. And the standard is that you are someone who is of the small percentage who's risen to the very top of your field. So quite a high standard for this visa type. The other type of visa, temporary visa for extraordinary ability, is the O-1B visa. And this is a temporary visa for individuals with extraordinary ability in the arts or extraordinary achievement in motion picture or television industry. And there's kind of two different standards here. So one for the arts, someone has achieved distinction within their field. And then the other is for motion picture or television industry. This is a slightly higher standard, that the person has reached a level of acclaim substantially above that of his or her peers. So these are both temporary visas. We'll talk a little bit more about kind of the parameters around these visas, how long they can be granted for, extensions, things like that, and further slides. But these are the ones you'd be looking for if you have a job offer in the United States, or you're an artist, you're in a band, you want to come and do tour dates, things like that. These are the temporary visas that you would look at. So let's talk about the EB-1A green card. So a green card allows you to live and work in the United States permanently and to eventually apply to become a U.S. citizen if you so choose. So for people who do want, a longer term ability to remain and work in the United States, they would potentially look at the EB-1A green card. And so this is for people of extraordinary ability in the sciences, arts, education, business, or athletics. And the standard is, similar to the O-1A. So somebody who's of a small percentage who's risen to the very top of their field, has sustained national or international acclaim, and achievements have been recognized in their field of expertise, and that they're planning to continue to work in that field of expertise. So for the EB-1A, it's not separated out between arts and business the way it is with the O-1A and the O-1B. So if you're coming from an O-1B, where the standard is a bit lower, it's distinction, and you want to apply for an EB-1A, it's good to kind of discuss with your attorney, as to whether you should perhaps wait a few years, build up your profile, and apply again, just knowing that, the standard, even though the standards will look very similar between the O-1A, O-1B, and the EB-1A, there's a higher standard that's essentially applied for the green card, since it is permanent. And we'll talk a little bit more about how they approach those in future slides. All right, so digging a little bit more into the O-1A visa. So for this visa, you have to demonstrate either that you have received a major internationally recognized award, for example, a Nobel Prize, a Pulitzer Prize, or much more commonly, people are going to submit evidence of at least 3 of the following that are listed here. So internationally recognized prizes or awards, membership in associations in your field, which require outstanding achievements, published material in professional or major trade publications or major media about you and your work, original contributions of major significance in your field, authorship of scholarly articles, high salary compared to others in your field, participation as a judge on a panel or individually, and employment in a critical or essential capacity for organizations that have a distinguished reputation. If there's other comparable evidence, because none of these apply to your field, you could potentially try to argue for that. Ideally, you're going to submit more than 3, but 3 is the minimum that you would need to submit to make an argument for the O-1A. And, one thing to consider is that, like not everything is equal, right? So if you get an award, in college, for having the highest GPA in a class, that's not going to be an award that is really, useful for something like the O-1A. These do need to be nationally or internationally recognized prizes or awards. So, if there's a really well-known trade association or something like that, that is, issuing awards, you would need to show that you won the award. And then you also need to show the criteria for how people are selected to win this award. And ideally, this criteria should be very stringent to be, useful for an O-1 application. So it is something where you do want to talk to your attorney before you, just submit every single piece of documentation you have, because there's certain things that just may not be very relevant. So most awards you're going to win as a student, if they are based on being a student, are not going to be useful, versus if while you're a student you win an internationally recognized prize or award, that could be included. Similarly with memberships, you need to think about, is this just a membership that anyone who has this, anyone who's a lawyer can join, the bar association, and you pay a fee? That's not going to be very useful for, an O-1A. It would be more looking for memberships or associations where there is significant achievements that you have to have in order to be invited to be a member, other than just kind of, paying a fee and kind of, having earned the degree. So those are things to consider when you're gathering evidence for an O-1A. I see someone had raised their hand, so we will have time for questions at the end, and so please send your questions to the chat box, and we'll definitely get to those towards the end of the presentation if they're relevant to the extraordinary ability categories. All right, for O-1B, so you'll see here that it's similar in terms of the structure of the requirements. So it's either, nominated or received a significant national or international award or prize, like an Emmy or a Grammy, or evidence of at least 3 of the following. And you'll see here that these are, because this is the arts category in the motion picture and television industry, the requirements are much more focused on, what would be relevant in those types of industries. Since arts can kind of encompass a lot of different things, sometimes you have to get creative. For example, record of major commercially or critically acclaimed success in the performing arts, that may not apply to everyone in the arts. So it may be a situation, where other comparable evidence can be used, again, depending on how you're defining your industry. Certainly, over time, different niche industries like tattoo artists, people doing, certain types of brewing, like, for alcohol and things like that. There's lots of different kind of creative uses for the O-1B that are outside, what you would normally think of somebody coming, just as a singer or an actor. So it is more expansive than that. But you do, similar to the O-1A, have to demonstrate that you meet at least 3 of the following, and ideally, again, more than 3, would certainly strengthen your application. But along the same lines, you need to be thinking about, what is the quality of the evidence? How prestigious are the performances, or, any of the material about you? And you want to be sure to make that clear, so the officers feel that there's, you reach that standard of distinction. All right, let's talk about the differences between the O-1A and O-1B. So we've already distinguished that the fields are different. So, O1A is for sciences, education, business, or athletics, and O1B is for the arts or motion picture television industry. We've talked about the fact the standards are a bit different as well. So the O1A, generally has a higher standard. So if you are in a situation where your case could arguably be O1A or O1B, you may want to strategically choose O1B because the standard is a bit easier to meet. So if you feel that you can argue, that it is, qualified and under the arts, that may be, a place to go instead of trying for the O1A. Both of these visas can be issued for the same length of time. So you can get them initially for 3 years and then get extensions of 1 year. If you are doing kind of a brand new set of projects or a new employer, you can get another 3 years. But if you're just continuing on with the same employment or finishing up the same set of projects you were initially approved for, then the extension would be 1 year. And can your family come to the US? Yes. So any, unmarried children under 21 and your spouse can come with you to the United States. They can study here, but they cannot work. So that would be something to keep in mind, for your spouse. All right, let's talk about the EB-1A green card. So we haven't listed out the requirements here, but they are essentially, they mimic, the O1A and O1B. And the setup to qualify is very similar. So it's either one major internationally recognized award or much more commonly meeting at least 3 out of the 10 criteria. And an important thing to remember with the EB-1A is something called the Kazarian analysis. So this is where the government, when you submit evidence, they'll look at the evidence to see whether you meet the plain language of that criteria. So are you a member in associations, which require outstanding achievements of their members? Have you won awards? Like, do you have published material about yourself in major, trade publications? And then in the second step of this analysis, they're going to consider in totality, when they look at everything all together, does this show that you are somebody who has risen to the very top of your field, someone of a very small percentage of people who've risen to the top of your field of expertise? So that is something you want to think about, that with the evidence you're submitting, you want to be sure that it's leaving the overall impression that you are somebody who, is an expert in this field. And that's where what I was talking about earlier with maybe you don't include, student awards or anything that is kind of, maybe meets the plain language of the criteria, but maybe isn't viewed as in as strong a manner. So it is something you want to consider, that they will be looking not just, do you meet the criteria? So, if you are a member of, 3 amazing organizations, and then you also are a member of a couple of those organizations where you just pay dues and a fee, don't include those, those other 2. Like, those are not helping you. You want to just focus on the ones that, show that, you needed to have outstanding achievements to be able to be a member of that association. So now what we're going to do is switch gears a little bit, and Jiyae is going to talk to us about the national interest waiver, which can sometimes be a good option for people who are considering an extraordinary ability visa, but maybe don't quite meet the EB-1A standard yet.
Thank you, Kelly. All right, so let's talk a little bit about the NIW. So the NIW is a green card option, right? So it is not a non-immigrant visa, it is an immigrant visa. So if you are approved for the NIW, you can apply for an immigrant visa if you're outside the United States, or if you're within the United States and your priority dates are current, you can apply to adjust status to a green card holder. And this will eventually, if you choose to do so, lead to citizenship. Now, there are a few eligibility requirements that you need to show that you meet in order to obtain the NIW. So the first thing to consider is, do you meet the EB-2 threshold requirement? And this is the minimum threshold for all EB-2 based petitions, even before trying the NIW, right? So you do need to show that you either have an advanced degree, which is defined as a master's degree or above. So, for example, if you have a PhD in your field, if you have, an MD or a JD in your field, that also counts as an advanced degree because you need a bachelor's in order to qualify for those degrees. Or if you can also qualify as as someone who holds the equivalent of an advanced degree if you have a bachelor's degree in your field, and if you have 5 or more years of progressive work experience in your field after you attained your bachelor's. So what does it mean to have progressive work experience? This means that your job duties and your job title and, just the general characteristics of the job did not stay the same over the period of the 5 years, but they changed. And they change with more complexity in the duties that you've performed, the more seniority in the responsibilities that you took on. So they're really looking for a progression in your career when we're talking about the 5 years of progressive work experience for the purpose of meeting the advanced degree threshold. Now, if you don't have the master's and if you don't have the bachelor's, there is still another way you can potentially qualify for the EB-2 threshold, which is by showing that you have exceptional ability in the sciences, arts, or business. And how do you show that you have such exceptional ability? First, the first step of the inquiry is, do you meet 3 out of the 7 criteria that is listed out here, the plain language of the evidentiary criteria? So these things include, for example, 10 years of full-time experience in your field, showing that you merit a high salary as compared to other people in your field, showing that you have evidence of being recognized for your achievements in the field by your peers, by industry organizations, government actors, etc., by things like awards, media mentions, being shortlisted in conferences for, an outstanding product, for example, publication of patents, papers that have been cited a high amount of times. Things like that can really show that you have been recognized for your achievements in your field. Now, it is important to go over the fact that exceptional ability does not mean extraordinary ability. And we have discussed at length what extraordinary ability means in the, O-1A and, O-1B and EB-1A context. Now, exceptional ability is different, whereas extraordinary ability really, for at least for the EB-1A context, it requires you to show that you have reached the very, very top of your field, one of the small percentage that have reached the very top. Exceptional ability for the EB-2 threshold does not require that much, that high of a level of achievement. In order to meet exceptional ability, the definition is that you possess a degree of expertise significantly above that is ordinarily encountered in the field, significantly above what is ordinarily encountered. So you can see that that is certainly very different from the standard that, that the government will use to adjudicate EB-1A petitions, for example. So now let's move on then to talk about the NIW criteria. So you do need to meet both the EB-2 threshold and also show that you meet the 3-prong NIW test in order to be approved for, the EB-2 NIW green card petition. And the reason why you also need to prove the NIW is that usually the alternative to this process, is that you would usually have a US-based company that will sponsor you for a position, and you would, the company would go through the labor certification process, which is, quite a lengthy and complicated process that really tests the labor market and shows that there is no other US worker that is available to fill your position, right? Fill the position that you are intending to fill. But if a person is eligible for the NIW, we don't need to go through all of that. And in fact, the NIW is one of the few categories where the person, the beneficiary, the person who will get the visa, can self-petition as a foreign national without the need for a US job offer, without the need for a labor certification process, without the need for a US company sponsoring them. So that is why it is important to, meet the 3-pronged national interest waiver test to really show that you are, you merit that exemption. So what is the 3-pronged national interest waiver test? The first prong is that the person must show that their proposed endeavor must have substantial merit and national importance. And what does that mean? Substantial merit can be shown in a wide variety of fields, including business, health, education, science, technology, and endeavors that tend to further human knowledge in those key areas, such as, medical advances, working towards, improving methods for civil engineering, things like that, can really be helpful in showing substantial merit. Now, what about national importance? In talking about national importance, the government really looks at what is the potential prospective impact of your work in the United States. So they're looking for a broad impact to the field as a whole, to the field more broadly, as opposed to just benefiting your immediate employer or your immediate clients. And another strong consideration in this inquiry is that can you show that your work will have a strong economic impact to the United States? And really, the question is to ask what is the expected future impact of your work and how is it important to the United States? And for example, if you can, research some government reports showing that certain areas are key to the U.S., competency and U.S. national priorities, such as, artificial intelligence technology, which is, something that all governments are trying to advance at this time and age, or things like sustainability and environmental justice. Developing, alternative ways of generating energy, for example, those can be very attractive fields that the government is currently focusing on as a priority. And if you can show that your work in your field will, significantly contribute to advance those key areas that the U.S. is, currently focusing on, that can be very helpful for the national importance argument. The second prong is that the applicant, the beneficiary, will be well positioned to advance the proposed endeavor. And what does that mean? That really means that the applicant must show that they have the education, they have the experience, and that they really have a past record of success in previous related projects that position them well, gives them the tool sets, gives them the skills and abilities to really drive that project forward to success. And the third prong is that on balance, there must be a showing that it would be beneficial to the United States to waive the requirements of a job offer and thus a labor certification to that particular individual for that particular project. And there are various ways we can argue this, this prong. So one strategy is to rely on prong one, which is substantial merit and national importance of the proposed endeavor. We can show that the person's work in the United States will bring broad systemic benefits to the field as a whole by improving a particular area of technology that can really, spark progress for the field as a whole. The other strategy is to rely on the second prong, which is focus on the person's unique know-how and experience that other U.S. workers with minimum qualifications simply may not have, and it is irreplaceable by those people. Other special considerations you can rely on for the third prong is that, for entrepreneurs, especially if the business project, for example, is expected to bring substantial economic benefit to the United States, especially in economically depressed areas and, census tracts that the government has designated that is in need of economic revitalization, that can really help with the argument that on balance, job creation and tax revenues that are being siphoned into that area is, merits consideration in the balancing act between, the ordinary benefits of a labor certification versus the strong benefits and national interests that this project will advance. All right, so we'll move on to the next topic now. Expert opinion letters. It is important to discuss expert opinion letters because they play an important role in, both O-1, EB-1A, and NIW petitions. And the purpose is a little different for each types of petition. So for example, for EB-1A and O-1 petitions for extraordinary ability, usually you would want the experts to confirm that you have extraordinary ability, the beneficiary, right, in the field, and the person is well known in the field, and really try to, gather the examples to prove that they have sustained national and international acclaim in their fields of endeavor. For the NIW letters, the purpose can be a little different. So some letters for the EB to NIW can, serve to support the national importance of the proposed endeavor, such as a letter from an interested government agency, for example, that can really explain the potential impact, the broad impact that the person's work stands to have in the field. Another type of letters that can support an NIW case is focusing on the well-positioned prong. So the letters can talk about the applicant's past contributions to the field, and really support, the argument of how they are well positioned to advance the proposed endeavor. And other types of letters that can be relevant for the NIW are, letters from economists, for example, that can write a report on the economic impact, the projected economic impact on direct and indirect job creation from that business endeavor. Now, let's talk a little bit about who is writing the letter. We really want to get letters from leading experts in the field who have, typically have decades of experience. And for extraordinary ability and NIW petitions, we typically include the full curriculum vitae, the full resume of that expert who is providing the opinion. That really positions them, in USCIS's eyes as someone who is qualified to provide that assessment regarding the merits of someone's work and regarding, the caliber of someone's work in the industry. So it is very important to obtain letters from experts who hold these senior positions in the industry. In leading institutions, that would be, ideal to get, right? So you really want to look for people who are already recognized as leaders in your particular field. For the NIW particularly, if you can get a letter from a government institution that is relevant to your proposed endeavor, if you can get, if you're planning to operate a business in a particular locality, and if you can get a letter of support from, the mayor of that city, or, a regional, a state level, congressional representative, for example, that can also be very helpful in, the national importance requirement. So that is a special consideration for the NIW. Now, another question to ask is, how does the individual, the letter referee, how does the person know you, right? And we would recommend having, usually a mix of independent and inner circle experts. So independent experts are people who don't know you personally, right? And people who are in your field and who have expertise in your field, but they don't know you by having worked directly with you. Rather, they can know of you through your work or through your reputation in the industry, right? And those letters are important because USCIS can consider them as more objective. And so those independent letters can confirm that your abilities are outstanding in your field, or that your work stands to impact your field, coming from a objective, third party person who is active in your field and has that expertise, who can attest to your reputation. Now, inner circle experts. Let's talk about inner circle experts. Those are people who have worked with you in the past, and those types of referees can speak in detail regarding your previous work and your achievements in the past, which are very important in both extraordinary ability petitions and NIW petitions. By either showing, that you have made achievements that have been recognized in the field broadly, or by showing that you are well positioned to, advance your proposed endeavor that stands to have that impact. So it is very important to, get letters from these inner circle experts who can provide a detailed testimony about what exactly you did, how was it different from, the typical approach that experts in the fields would typically take, and how did your approach improve upon, existing approaches. Those kinds of, key narratives can really come out by those expert letters. Now, what will be the content of those expert letters? It is very important to include a detailed discussion of your work, the recognition that you have earned as a result of your work, and accomplishments and achievements, really with a focus on how does your work set you apart from others, and also describing why these achievements were important for the field. And really, it is important to be as specific as possible in those descriptions, because USCIS tends to not rely on general or conclusory statements. So, for example, letters that are formulaic and simply copy paste, the regulatory requirements, such as, applicant is a very well-known figure, or just saying, the applicant's project has national importance. Those kinds of sentences taken on their own will not be enough to, persuade USCIS of, those arguments, because those statements can be taken as conclusory and general. So that is why eliciting specific examples and concrete examples of your past work, and eliciting specific explanation of the impact of your future work will be important, because those examples will support why you are extraordinary or why your project in the United States stands to have national importance. All right, so let us move on to the next topic then. Which category should I apply for? So we have discussed a variety of different options that are available for people who have extraordinary ability, including the O-1, including the EB-1A green card, and including the EB-2 NIW green card. Now, the first question to ask is, do you want to stay in the United States temporarily or permanently? So as Kelly mentioned earlier in the previous slides, the O-1A and O-1B are both non-immigrant visas suited for people who intend to work temporarily in the United States. Whereas the EB-1A and NIW are green card options. They are really meant for people who want to live in the United States permanently. And also the EB-1A and NIW are both green cards that can lead to citizenship in the future if that is something that you are interested in. The advantages of the O-1A and O-1B is that it gives you the freedom to travel in and out as much as you want and as long as you want, right? So for the EB-1A and NIW, once you become a green card holder, there are certain restrictions of how long you are required to stay in the United States, how short your trips need to be when you're moving out of the United States. So there are some restrictions. But for the O-1A and O-1B, you have that freedom to come to the US as often or as little as you want. And also another advantage could be that non-immigrant visas tend to be faster to get. So if you need to come to the United States to start working on your project sooner than later. Now, the green card options are typically slower. And with regards to the EB-2 NIW, there has been a backlog in the priority dates, which means that more people are applying for the visa than there are enough visas available for a given year. So we have been seeing that some clients, even after they were approved for the NIW, they may be waiting in line for a year or so before the priority dates become current and they can adjust status. They can apply to adjust status to become a green card holder. So timing can be a significant consideration in that regard. The other question is that, do you have a US-based employer or agent, or do you want to self-petition? So as Kelly mentioned earlier, the O-1A and O-1B does require a US employer or a US agent to act as the petitioner of the case. By contrast, the EB-1A and NIW both allow the beneficiary, the foreign national themselves, to self-petition for the case. Now, for entrepreneurs, it is something to consider that for the O-1A, if you establish your own company in the United States, right, that is considered a separate legal entity from you. So if you found a company and that company wants to act as the petitioner, that is possible if it is a US-based entity. So for entrepreneurs, that can be one solution that could work for you if you want a O-1 visa. Now then, for the last one, let's talk about family considerations. So as Kelly mentioned earlier, for the O-1A and O-1B, the spouse and minor children under 21 unmarried can come to the United States with the principal O-1 holder as O-3 dependents. However, there is no work authorization that is available for spouses hold an O-3 visa. Although the spouses and children can study in the United States, but there is no work authorization available. Now, by contrast, the EB-1A and NIW are green card options, and the spouse and the minor children can also apply for green cards along with the principal beneficiary. And, and by having green cards, this means all of the benefits of having a green card also come with it, right? So if your spouse is applying with you as a green card holder, the spouse will also get a green card at the end and can, work for any person they want or not at all. And so if you are, if your priority dates are current, and if you choose the option to adjust status to green card holder with what is called an I-485 application, your dependent applicants can apply with you, and your spouse, for example, can apply with you. And the ordinary benefits of a work authorization and travel authorization that you can apply for, the spouse can also get. So that means if and when you apply for a I-485, you could also apply for an employment authorization card, an EAD, right? And your spouse can do the same. So once you have the EAD, you can, really start working for anyone that you would like in the United States. So that can be a significant advantage for some people. All right, so we will move on to the next topic now. Right, let's talk a little bit about strategic considerations when you're moving from a non-immigrant visa to a green card, which is a scenario that we see often. So the first thing to consider is the difference in the qualification standard. So as Kelly mentioned earlier, the O-1A and O-1B is typically approved with a lower standard than the EB-1A, which is the green card option for extraordinary ability. And it is a first preference green card option. And it is very scrutinized very carefully by USCIS just because of the high level of expertise that is required for to qualify for that coveted green card category. So, and in particular, if you're trying to go from an O-1B to EB-1A, that can be a little harder because to be approved for O-1B, you just need distinction in the field for the arts, right? However, it can be a big leap to prove that you have sustained national or international acclaim, which is required for the EB-1A. So that is another strategic consideration you should think about. Now, timing. Let's talk a little bit about timing. If you have an underlying visa, a non-immigrant visa, it is very important to think about when you want to apply for an immigrant visa, if that is, within your plans. Because if you need to renew your non-immigrant visa, for example, right, it may be prudent to wait before filing the immigrant visa petition, because filing an immigrant visa may be an indication that you have immigrant intent in the United States. And this is typically a more important problem for certain visa categories, such as the TN visa, where even filing the I-140 can signal to a border officer who is, looking at your petition that, oh, maybe this person wants to become an immigrant in that particular visit. And there is a risk that, that your future non-immigrant visa renewals can be challenging. Now, dual intent visas are not affected by this consideration, such as the H-1B and L-1, for example. And to a certain degree, the O-1 is also, sort of a dual intent visa. So just by having filed an I-140 shouldn't really be a basis for denial in those cases. But, these are very fact-specific considerations. So definitely consult with your attorney first if you are navigating the strategic issue of timing of filing your immigrant visa. Okay, so let's talk a little bit about family. Now, if you have children who may also need the green card, that may be a reason for you to file the I-140, which is the immigrant petition, early, because once the child ages out at 21, that option is closed. So to avoid those issues, it may, be another reason why you may want to file the I-140 sooner than later. All right, so let's move on then to the last topic. Are extraordinary ability categories available for entrepreneurs? And the short answer to that is yes, it is available. Entrepreneurs can qualify for the O-1A, EB-1A, EB-2 NIW, provided that they are able to present the evidence that are responsive to those specific eligibility criteria for those categories. So let's talk a little bit about EB-1A and NIW. They both allow for self-petitions, which means you do not need a U.S. job offer. You do not need a U.S.-based petitioner to drive the petition forward. So entrepreneurs can just self-petition for their business project in the United States. So that is one advantage to consider. The second point is that with the new, case law that came into play since 2016, called the matter of Danazar for the EB-2 NIW, the case law changes made it more more advantageous, more friendlier for entrepreneurs to apply for the NIW. Generally, it became a little easier to meet the standards. And in 2022, there were updates made to the policy manual, the USCIS policy manual, which laid out the types of evidence that could be available for entrepreneurs to rely on to prove the merit of their endeavors and to prove that they're well positioned to drive forward the endeavor. So those changes in the NIW standard and policy made the EB to NIW a more accessible category for entrepreneurs. Finally, it is worth noting, again, that it is possible to apply for an O1A as an entrepreneur if you have a separate U.S. corporate entity that can act as the petitioner. Now, you still must show that there is some demand for your work in the United States. However, it is very much of an advantage to know that you can still use that structure to, become a beneficiary of an O1A petition. All right, so I think that is all that we have prepared for content. And now we'll move on to questions and answers. Okay, so for the first one about the L1 visa, I would like to remind everyone that we do have separate webinars specifically on the L1 visa that is available on our YouTube channel, and also there are a lot of resources that are specific to that. So I would definitely encourage you to check out the resources specifically on the L1 for these questions. And there may be, upcoming webinars in the future that will focus on that one. So please, follow us and sign up for the additional webinars coming up in the future. If I register in the new company in the United States, can I get an O1A or O1B visa? Yeah, so as I mentioned earlier, it is possible for an entrepreneur to set up a new company, which is a separate legal entity in the United States, and that entity can serve as the petitioner for the O1 petition. Now, regarding the fees, please reach out to us for a consultation. We will be happy to give you more guidance on that. I have a bachelor degree in computer science with software development experience. What category will be best for me? So definitely that is a question we would want to look at in more detail in a consultation. We do a lot of consultations, and definitely feel free to reach out to us, and we'll be happy to look at your CV and talk to you and try to provide our assessment on that. I'm aware of the prestigious professional and academic associations membership is one of the criteria for O1A. Could you give some examples of membership associations that meets this criteria? So one example that comes to mind is the IEEE Fellowship. Now, in order to become elected as an IEEE Fellow, you need to go through a very stringent assessment procedure judged by a panel of experts who are designated to screen applications. So not everyone who is an IEEE member can be an IEEE Fellow. So those kinds of very selective organizations usually would be well suited for meeting this criteria. Kelly, do you have any examples that come to mind?
No, I think that's I think that it's going to obviously vary by, which industry you're in terms of what's going to count, but I think that's a good solid example.
Right. Okay, for the international award criteria, I recently secured Best Paper Award in IEEE International Conference. Would that one award suffice meeting this criteria? Right, definitely schedule a consultation for us to really look at the specific award and your specific field, right? Because the award also needs to be in your field and needs to be related, right? Regarding, having one award, in the general question, does having one award satisfy the criteria for having an award? And assuming that award is nationally or internationally recognized, it is possible to technically meet, the first stage of the Kazarian test by, showing if you have one award, then yes, you will meet that criteria. But on the second stage of the Kazarian, analysis, you will need to show that in totality, your entire profile shows that you have reached that level of expertise required. So that is definitely a more complicated analysis you may have to do. I'm an OPT F1 student. I have a Master of Science in Data Science. Will there be a problem to renew my OPT if I file for an EB-2 NIW? Kelly, what do you think?
Yeah, I mean, I think that it's ideally you would apply for the the EB-2 NIW maybe after you renew your OPT. I think that when you do the I-140, generally to keep your options open, you're going to select consular processing. You wouldn't
Right.
select that you're going to adjust status in the United States. So even if you did file it before, as long as your intent is not to adjust on this entry, arguably you still maintain appropriate intent for the OPT renewal. But if it's possible to change the timing so that it's, not until after you file, you could also consider that.
Yeah, definitely. I agree with that. And yeah, regarding, the membership criteria, yeah, there are many examples, but it does depend on your particular field. So reach out to us if you would like, more specific guidance in that area. Okay, so it seems like we went through all of the questions. I hope this session was helpful for everyone. Thank you, Kelly, for sharing your expertise, and we will close here.
Thank you.